So one is safety, second is liquidity, third is profitability. As we all know that we are profitable, we have to be a profitable business. So bank will do customer profitability analysis for all their customer. It will depend on the risk which the bank is taking in each kind of loan. In home loan, there will be some lesser risk because mainly we are providing it to retail customer. Size of the loan is not that big, but if we are giving loan to for business and suppose we are giving 1,000 crore rupees, then the risk is going to be very high. That is why customer will do this customer profitability analysis, that how much profit we are going to earn from our home loan portfolio, how much business we are going, or how much we are going to earn from lending to businesses. And also we have to see that we are taking risk which is not beyond what is the policy of the bank. Purpose Purpose is that it should be for productive purpose, and if borrower has to repay money, she will have to use it wisely and not merely spend the same. So for whatever purpose you are giving the loan, customer should utilize it for that purpose only. If you are giving the loan for car loan, it should be taken for purchasing the car only. If you are giving loan for home, you are giving home loan, it should be used for home only. This, as a banker, you have to go and check that they are not um, using it for any other purpose. Diversification of risk, as I told you, banks should avoid concentration risk. It will not expose to any one single borrower or group of borrowers or purpose or geography. It will try to spread it in different geography for different purpose and to different borrowers. Security, as I told you, we will be taking some of the security. So security offered against loan may consist large variety of items. It could be plot of land, building, flat, shop, ornament, insurance policy, shares, debentures, bonds. So these are all kind of securities which we take to protect our loan. That if the customer is, suppose when you are giving loan to a customer, suppose you gave loan to a businessman, and when you gave the loan, his business was running very fine. He was earning a lot. And after 4 5 years, the business is not doing good, or whatever business they were doing, that has become obsolete. And in that case, businessman is not able to repay the loan. Although there was income generation for the businessman, but now he is not in a position to repay the loan to the bank. And that in those cases, bank will sell these security to get their money back. Now there are 7 C's of credit is another conceptual framework. So 7 C's is character. First is character. Character of the person to whom we are giving the loan. Like if we are giving loan to Mr. B, we have to see that what kind of character he is. Whenever we are giving loan, we have to do some field work. Field work means we will go and ask the resident who are living nearby Mr. B. We will try to understand what kind of character this person has, whether we should trust him or not. And for that, we will go to his employer, we'll go and check his residence also. We will ask people around him that how this person is. So first is character of the borrower, second is capacity. They should have capacity. If he is earning any income, then only he will be able to repay the loan. Capital, if he is starting a business, or even if he is taking a car loan, bank will never provide 100% of the capital for any loan. Some of the capital should be provided by Mr. B also. So bank will check that what his net worth is, how much capital he can bring to the table. Next is collateral. What security? Collateral is security which the bank will take. On what conditions you will give loan to the customer, what will be the term, what will be the rate of interest. Because nowadays what happens is that even in the same loan there are multiple rate of interest which is charged by different customers. Some of the banks provide Additional discount to women customers. Some of the banks will have their rate of interest which will depend on the CIBIL score of the customer. So if CIBIL score is good, bank will charge less rate of interest, and if CIBIL score is not that good, bank will charge more rate of interest. Cash flow should be there. Without cash flow, the customer won't be able to repay the loan. And credit worthiness should also be there. We will see that whether the customer is credit worthy or not. So these are 7 C's of credit that we have to keep in mind. Now, various borrowers can be classified as follows: individuals, and these are non individual customers. Proprietorship firm, partnership firm, HUF, companies, statutory corporations, trust cooperative society, and limited liability partnerships. So, individual customers, you can give loan to individual customers, but why we have to study this in loans? Why we have to study about different kind of borrowers when we are studying loans? Do we need to study this? Do we need to study this? In loans especially, why should we study this in loans? In deposit, we are going to study about this. We have to study this in operations, because we have to keep in mind what KYC documents you will take, or what kind of documents will you take when you have to open in any account. See, this is very true that entity type will be required. This is also correct that we need to assess the type and capacity of customer. One of the thing that is very important, and why we have to read this in operations also, and why this we have to read in loans also, the different kind of customers. One thing is that with different customers you will have different kind of relationship. You will have to take different documents. You will have different acts which will be applicable. You have to understand because in loans we will have some contract with the customer. There will be some terms and conditions on which you are giving loan to the customer. So you have to understand that whether that person is eligible for that particular contract or not. Like in the case of minor individuals, we can open their account. They can open, if they are below 10 years, they can open their account with their natural guardian, and above 10 years they can open independent account. They don't need to have joint account. They can have joint account, but it is not compulsion. They can have single account also. But in case of minors, we cannot get into any kind of contract with them. They are not allowed as per law. Minors cannot be sign any contract, and that is why we, while doing the loan, we can open the account, but while doing the loan we cannot give loans to minor. That is why it is important to understand that what are the conditions on which you can give loans to any customer. It will not be the same as opening account. It is going to be different for different individuals. So bank will lend only to individuals who are of sound mind, who are not minors. Why we are excluding individuals of sound mind and minors? Because they are incapable to understand the terms and conditions of the loan, of the contract which we are going to sign with the customer. Individuals who are not of sound mind and who are minors, they cannot understand the terms and conditions. They cannot understand the contract itself, and that is why they are excluded. Dealing with individuals are governed by Indian Contract Act. So it is under Indian Contract Act. Bank, while lending to individuals, should ensure that borrower is competent to enter into a contract. there are cases, not just in case of minors and individuals of sound mind, there may be cases where a customer has been barred by the law. Court has ordered that you cannot give loan to any particular customer. That you also have, that also is the responsibility of the bank, that before lending to a customer you have to see and you have to check that whether they have been any restriction which has been imposed by any court of law. Because in those cases, if suppose a banker gives the loan to those people who are not eligible for taking the loan, then you cannot go for repayment, you cannot go to the court for any case after that. That is why it is important to understand that whether you can give the loan to the customer or not. So money lent to following individuals who are not competent to contract cannot be recovered. That is why, because it cannot be recovered, we will exclude these kind of people who are not eligible as per the law. First is minor individual. Anyone who has not achieved 18 years will be called minor, and this comes under Indian Majority Act. According to law, minor is not capable of entering into a contract, and a contract which is entered into by a minor is void. And that is why we cannot have any kind of contract with them, and that is why they have been excluded from taking loans. Asset pledge against an advance granted to minor are not available for appropriation of dues. You cannot sell their assets. As in other cases, we can sell. In case of minors, you cannot sell. That is not allowed by the law, and that is why we will not give loan to minors. But we can give loans to the to minors if it is used for their supply of necessities. If suppose a minor is there who lost his or her parents, and they need supply of necessities, and the minor is having some assets in his name because of some inheritance. In that case, loan can be provided to the legal guardian for the supply of necessities to him. And in that particular case, the asset, the estate of the minor, can be used for recovery of the money. So this is under section 68 of Indian Contract Act, that property of minor will be liable for that loan. So this particular law is important, that this will give the right to the banker that only in this exceptional case bank can give loan to the minor. Guardians may borrow on the behalf of the minor. So guardian could be mostly legal guardian. Not of sound mind, again, they are incompetent to enter into contract as per section 12 of the Indian Contract Act 1872. So ha- they cannot take loan from the bank. A person will be considered not of sound mind if at the time when he makes contract is not capable of understanding it, or and of forming a rational judgment as to its effect upon its interest, and that is why they will be excluded. There are some disqualified person who are not permitted by any kind of law. Any law has restricted any kind of loan to certain people, they will be called disqualified person. There may be statutory disqualification imposed on a person in respect to her capacity to contract. The contract entered into such person is not enforceable as per section 11 of the Indian Contract Act. So for disqualified person, it is section 11. In case of not person not of sound mind, it is section 12. Married women, can they take loan? Married woman can take loan. She must have means, and borrowing should be commensurate with her requirement and her ability to pay. If they are earning themselves, they can definitely take the loan. Husband will not be liable for her borrowing except where he has joined as co-borrower or as a guarantor. Otherwise, if a married woman is taking loan in single name, they are You have to do the inquiry work. Generally, we do the inquiry. We have to field visit. We have to ask people around him. We also go and ask employers about the person. From that, generally, you get to know. So that is why field visits are important. We have to do the pre-sanction work also, where we have to verify the customer details, and also we have to verify the KYC. Sometimes it happens that even the KYC are not correct. Now, Parda Nashi women, they can also take loan. There is no, it is, they are not barred from any kind of law that they cannot take loan. The only problem is you have to ask them before lending. You have to ask them that they are not under any kind of pressure from their uh, family to take the loan. Parda Nashi are who observe complete seclusion in accordance with the custom of our community. She is qualified to get an advance sanctioned and has the capacity to enter into a contract. So loan can be given to them. The only thing is you have to be little more prudent, that you have to ask them questions. Practical issue may arise at all stages of lending, ensuring the identity of the borrower woman. First challenge is finding the identity of borrower woman. Second is possibility exists of plea may be improper and undue influence. So second is undue influence on them. This is the second challenge. Such cases would require additional measures and precautions. So you will have to ask the customer, or as I was posted in branch manager as a branch manager, I used to call those Pardhanashi women in my cabin, and I used to tell them to show me their face. So if any female staff is posted, you can ask them to verify their face. If anything related to loan is there, it will be reflected in CIBIL. If there is any case related to loans, it will be reflected in the CIBIL, whether it is written off, where there is another any doubtful loss cases, everything will be reflected in the this CIBIL. But if it is not related with loan, there could be other reasons also because of which they have been barred by any law. So that you have to do only through inquiry. That will not come under CIBIL, because CIBIL will get data only from the banks. So they will be having related to loans only. Now comes illiterate person. You can give loan to the illiterate person. They are capable of entering into valid contract, and most of the farmers we give loan, the most of the farmers I have encountered, they were illiterate, so we used to take thumb impression in those cases. If both hands are lost, foot thumb toe impression can be taken. Extra precaution to be taken, that document should be read out, explained to the executant. So whenever you are giving loan to any illiterate person, you have to take some witnesses. You have to explain the terms and condition to the illiterate person, that on what terms and conditions you are giving the loan. Suppose you are giving KCC loan, you have to tell them that we are giving you we are giving you loan of 1 lakh rupees. You will be charged 7% of rate of interest. You have to, because you are having this short term crops, you will have to come to the bank at least 2 times in a year, and you have to deposit the money, and then again you can take back. So you have to tell all the um, terms and conditions on which you are giving loan to them, and you also have to take witnesses in those cases. And a recital to this effect, duly witnessed by a third party, may be obtained and held with the document. So this is regarding the individuals. In individuals to whom we will not give the loans, In case of individual customers, individual borrowers, what are the categories to whom we are not going to give the loan? Minor and correct. They will be called disqualified person. Married one, married woman, you can give loan to married woman. If I am earning, you cannot give loan to me. If I am earning, I come to your bank, I come to your branch, will you not give loan to me? Married women can avail loan if they are earning, they are capable, they have capacity to pay the repay the loan, then they can take the loan. Husband will not be liable if husband is joining as a co-borrower or guarantor, then only liability of the husband will be there. Even in case of women who are not earning, you can give loan to them. In those cases you have to take husband as co-borrower. You will see in many of the cases most of the states provide concessions on registration of property. So what most of the families will do, they will keep women as the first applicant and husband as second applicant because they get some benefit in the registration of the property. So even in those cases we give loan to them, but husband will be taken as co-borrower and husband's salary is taken for repayment. Is it clear, Chaitanya ji, Vinod ji? We provide loans to non-working women also, but we need someone to add as a co-borrower because we'll be taking repayment from them. Is it clear? Chaitanya ji, Vinod ji, we can give loan to them also. When we are considering salary of another person, then we will add them as co-borrower. When we are considering the salary of another person, then we will add them as co-borrower, not as guarantor. So we will not give loan to minors. We cannot give loan to people who are not of sound mind, and we will not give loan to disqualified person because in case of disqualified person, they are not allowed by any court of law. Or in case of unsound mind and minor, they cannot enter into any kind of contract. That is why we cannot give loan to them. Rest others we can give loan to them, but we will, in each of the cases we have to be little careful that what guidelines are given by the bank, we will follow those guidelines. Now comes proprietorship firm. What is a proprietorship firm? Where the business is owned by an individual, they are known as proprietorship firm. Usually they don't keep the account separate from their own earning. That issue comes while lending to these proprietors. So issue which is encountered in lending is the absence of proper account and segregation of individual account from the business. That is the problem which comes under proprietorship firms. Like individual dealing with proprietorship firm are governed essentially by Indian Contract Act, because proprietorship firms usually the same person is doing everything, so he will not maintain two accounts, one for the company and one for himself. That is why the only problem which is encountered is this, that they are not separating, and it becomes difficult to understand how much he is reinvesting, how much the company is earning, and that becomes a problem. But otherwise we can give loan to proprietorship firms, and we give a lot of loan to proprietors. Now comes partnership firm. So partnership firm is going to be little longer. I'll ask few questions with you. In case of partnership firms, we had discussed that uh, in case of partnership firms you don't need registration, but when you have to give loan to for partnership firm, you have to get the firm registered. Anyone having any idea why? Giving loans to partner, we have to understand because it is more complex. Why we have to get the partnership registered when we are giving loan? If you have to open the account, registration is not mandatory, but if you have to give loan to a partnership firm, then you have to get it registered. There is liability concept to it, and we will see what are the problems with partnership firm. So partnership firm act, the Indian Partnership Act 1932 governs partnership firm. Section 4 of act says partnership is the relation between person who have agreed to share the profit of a business carried on by all or any of them acting for all. So what does this mean? Any of them acting for all. Suppose A, B, C became partner. They all have invested their money, but C has decided that it C will not take part into the management. A and B will be the active partners. C can be the sleeping partner. So he has invested his money, but he is not active partner. So this can be done in partnership firms. So this is what it means, carried on by all or any of them acting for all. So A and B will be acting for all three, A, B, C, but C is actually not participating actively. Relationship between partner is governed by the partnership deed. We have to take partnership deed when we open partnership accounts. Dealing with partnership firm are governed by the Indian Contract Act. So Partnership Act 1932, it governs partnership firm, but when we have to do any kind of dealings, if there is any kind of contract, then it will again be taken care of by the Indian Contract Act, as in the case of individuals, also in the case of proprietorship firm also. We have seen that Indian Contract Act will be governing the contracts with the party. Legal position of partnership: a partnership is not distinct from its partners. It is not considered as different from, like in case of companies, what happens is, if A, B, C are three partners and partnership firm name is ABC Limited, then these are considered as four different entities: 1, 2, 3, and 4. This is in case of companies. But in case of partnership firm, ABC Limited is not different from ABC individually. So it is not distinct from its partner. Section 18 of Partnership Act reads, subject to provision of this act, partner is the agent of the firm for purpose of business of the firm. Indian Partnership Act 1932 provides for registration of partnership but does not make it mandatory. So we can, if we have to open a account, saving account or current account, we can open the account without registration. In that case, registration is not mandatory, but if you have to do any loan, you have to get the partnership registered. You have to take the registration certificate. If partner does not act in the usual course of business of the firm, then his act binds the firm. This authority of partner to bind the firm is implied authority, which is given in section 19 of the Indian partnership. What is implied? You will see there are two words given. One is expressed and one is called implied. Any idea what is expressed and what is implied? These are different acts. Contract act will have contract act defines different kind of contracts, because whenever you are giving loan, you will be having some contract with the customer that they will provide you. Suppose if you are giving loan for car, then you will have hypothecation agreement. If you are giving loan for where any property is involved, you will be taking mortgage deed with them. So there are different kind of contract which we sign when we are giving loan to customers, that will come under contract act. Companies act deals with how the company will be made, how they will be incorporated, what terms and conditions should be there, and what are the rules of government of India under which the companies have to act. These all will come under Companies Act. Indian Banking Act, it is not Indian Banking Act. I think you are asking about Banking Regulation Act. Banking Regulation Act has lot of rules and regulation regarding how the bank has to work. Kartik ji, why are you asking me former and survivor here? Why are you asking me? Expressed mean if it is written. Expressed means if it is written. Implied means that you are assuming that if this is given to you, you have to do that. If you are a branch manager, it is implied that what your duties would be, how that you should be more prudent than all other staff. So that is kind of implied. Expressed is when it is written that as a branch manager you have to do so and so and so and things. No, don't be sorry. I asked you that I'm teaching you something else. Out of blue, you asked me former or survivor. Former or survivor is where the former will be operating the account. If former is not there, if he dies, then the right will go to the survivor. Former means the first name. The person who has first name in the account, he will be the first person to operate the account. Only when he is not there, maybe if he dies, then the survivor will have the right over the deposit which is lying in that particular deposit account. Section 22 of the Indian Partnership Act 1932 adds that the act which has done by the partner to bind the firm must be done in the name of the firm or in any other manner which implies an intention to bind the firm. Bind the firm means they want that firm is involved in it. Then whatever the partners are doing, as I told you, suppose A, B, C are partners. If they are doing something which is related to ABC Limited, They should do this in the name of ABC Limited, not in their own personal name. Although they are not different, partners are not different, but if they want to bind this, if they want to make the firm responsible, then they have to do whatever business they are doing in the name of ABC Limited. Any partner in trading partnership. What is a trading partnership? Trading partnership means where you're buying and selling something, that is known as trading partnership. So trading partnership has certain implied powers. Implied power means there is no express, it is not written somewhere, but it is implied that they will get this power, that they can borrow money on behalf of the firm for firm's ordinary course of business. They can, they have the power to sell or pledge any of the partnership property. This is allowed in trading partnership. Trading partnership means where you can buy and sell. There are some non-trading partnership firm, like uh, example could be, suppose 34CA, they have decided to start their firm as a partner. So that will be known as non-trading firm, because they are not selling anything. So they don't have such implied powers. They cannot borrow money on behalf of the firm. They don't have power or to sell or pledge any of the partnership property. They will have some rights over drawing and endorsing of check, but not these powers. A partner cannot give a guarantee on behalf of firm unless it is activity of the furnishing guarantee. So a partner will not give guarantee on behalf of the firm unless they are in this particular business only where they are providing guarantees. So there are some essential ingredients of a partnership firm. First is there should be association of at least two or more person in a partnership firm. As per section 464(1) of Companies Act, maximum number can be prescribed is 100. Maximum, according to company's miscellaneous rule, if a partnership is running for business, then maximum number of is 50 for partnership for the purpose of gain. There must be express, it is not express, it is express, I wrote the wrong spelling there. Express and implied agreement between the partner to do a business for gain. Trade, occupation or profession, that must be legal. So whatever business they are into, it should be legal also. There must be sharing of profit and losses in the business. The business must be carried on either by all or by one of the partner firm. These entities are not partnership, so these cannot become a partnership, society, association, club, joint Hindu family, a co-ownership. So first is there should be at least two or more person. Second is, according to Company Act, 100 is allowed. Account, according to company's miscellaneous rules, if question is asked you how many maximum partners can be there, you will have to choose 50. There should be express and implied agreement between partners that they want to do business for gain. Whatever business they are doing, it should be legal, and they will share the profit and losses of the business. So these are some of the essential things that a partnership firm should have. Now comes registration of partnership firm. Why need for registration? Need for registration is important. Although Partnership Act does not provide for compulsory registration of firm, but certain constraint from which an unregistered firm could suffer encourage partner to register firms. Registration is evidence. One is that registration is evidence of the existence of partnership. If firm's registration is not done, then firm or any other person on its behalf cannot file a suit. So suppose you are giving loan to a partnership firm, naming name is ABC Limited. This is a partnership firm. You have given loan to bank, name could be, suppose Bank of Baroda has given loan to ABC Limited. This is a non-registered partnership firm. Suppose ABC Limited sold some goods to Mr. X, and Mr. X had to pay rupees 5 crore to XYZ Limited for the goods which was delivered to Mr. X, and Mr. X had to make the payment of 5 crore. But Mr. X refused to give this 5 crore to ABC Limited. Then ABC Limited, because it is unregistered, it cannot sue Mr. X. So this is the problem with non-registered partnership firm. Till he is alive, he will operate, right? Until unless he gives power of attorney to another person, he cannot operate the account. Till the time he is alive, he will operate the account. So is it clear why registration is important? First is it becomes evidence of existence of the partnership firm. Second is can only means, Karthik ji, can only means only he can operate the account till he is alive. When he dies, the survivor can. No, survivor cannot. Till the time he is alive, survivor cannot. Only in some of the cases, like suppose in case of NRI, we studied that they can open account in former or survivor. So former will be the NRI, and survivor only the NRI can operate the account. Suppose NRI has to go back to his country, then he can give him power of attorney to operate the account. But even if they are given power of attorney, they can do few transactions only. Not all transactions are allowed under power of attorney also. So in case of partnership firms, if it is not registered, it cannot sue any other person for any kind of dues, and that is why partnership registration is important. Suppose Bank of Baroda has given 10 crore of loan of 10 crore to ABC Limited. 5 crore they were supposed to receive from Mr. X, but now Mr. X is refusing to give 5 crore to ABC Limited. Now, because ABC Limited is not registered, it cannot sue Mr. X. That is why registration is important in case of partnership firms. So I'm signing off for today because it is already time. Any of you would like to ask any question? Any question from any one of you? PDF will be provided just after the class. Once I will log out from here, I'll provide the PDF. You will get the full PDF. You can just go through it tomorrow before coming to the class. You can just have a look of the PDF so that you will know what we are going to do tomorrow. I'll provide you the whole unit. Any questions, anyone? In case of sole proprietorship, no registration is required, although we ask for their VAT registration or GST registration. That would be enough. Proprietorship firm, no registration is required. In case of partnership firms, you can open the account. If there is only saving or current account have to be opened, you can open the account, but you cannot give loan. If you are giving loan, you have to get the firm registered first, then only you can provide the loan to the customer. And I told you why registration will be important, because if this case happens, then bank will lose in that case. So that is the only purpose. So thank you all. We'll meet tomorrow then. Good night, everyone.